Who have been on the dinner circuit or continuing education circuit in the last couple of years, our next speaker won't need any introduction. He's been introduced about 20 or 30 times in the last year and a half. He's the hottest number in town right now. His Honor, Judge Clare Lewis.
Lord, Your Honors, ladies and gentlemen, I think I much preferred Michael's earlier statement about the ruling that there were to be no introductions. At the best, he's indicated a case of rampant overexposure on my part, and perhaps that's what leads to the smaller group of people here today than I've been seeing in past weeks. I'm here to discuss with you a recent development in the law of confessions, and as you've heard, I have a paper which will be made available to you of some length, and I don't propose to read it by any means in total. You can, while it's of course the last word on the matter, I leave it to you to decide whether it ought to be read, and if so, at your leisure. Back in 1979, during the current session, such as this, both Casey Hill and Harry Carlton, QC, delivered comments on the recent developments in the law of confessions, and those two articles, which have been published, are really quite definitive on the law up to that point. Indeed, they dealt some length and with some cogency the decisions of Horvath and the Queen, which is 1979, 49 CCC's second series of 385, Ward and the Queen, 1979, the same volume at 498, and Irvin, also in the same volume, at page 76. It was a big year in confessions. It might be said that one could be forgiven if, having read those cases, one felt that they heralded the adoption by the Supreme Court of Canada of a very liberal position in relation to the law of confessions. One might feel, for instance, that the court was taking a position which expanded the rules of voluntariness and which, considering Horvath in particular, indicated an aversion to certain police practices which were not considered suitable by the court in the taking of a confession and which might provide grounds for exclusion. Irvin might have suggested to some that, despite a warning in the case, voir dires must be held, that they were essential to the admissibility of statements in all circumstances. Well, certain decisions of the Supreme Court have, to me in any event, indicated a more conservative bent than otherwise might have been indicated. Those three decisions of importance in that court in the intervening 2 years are, in my view, Nagacha and the Queen, 1981, 51 CCCs at 353, Rothman and the Queen in 59 CCCs at 30, and Park and the Queen, very current decision, and also in 59 CCCs at 385. Now, we know in considering the law of confessions, one always has to return to the seminal decision of Ibrahim and the King, and one follows that through from Boudreau through Fitton, and I assume that you know the basic rule of voluntariness. Horvath and Ward dealt with it and expanded it perhaps slightly in this sense, that in Horvath and Ward, the court dealt with the issue of the operating mind of the accused. You will recall briefly the facts of Horvath. That's the chap who was charged with killing his mother. He allegedly, according to a psychiatrist in any event, and the trial judge, while being questioned in a protracted fashion, fell into a state of light hypnosis and made a confession shortly thereafter. The Supreme Court of Canada excluded that confession, as did the trial judge, but not the BC Court of Appeal. Might just mention in passing that Horvath, having been acquitted, is now doing, I believe, a life sentence in Ontario for 2 counts of subsequent attempted murder. Perhaps the police in Ontario aren't as learned in the arts of hypnosis as those in British Columbia. In any event, he lived to see another day. In the Horvath case, Mr. Justice Spence stated, "In my respectful opinion, the judgment of this court in Fitton must be limited so as not to rule admissible statements made by the accused when not induced by hope of advantage or fear of prejudice, but which are certainly not voluntary in the ordinary sense, English sense of the word, because they were induced by other circumstances such as existed in the present case. And in the Ward case, which you may recall, was a case of a man in a motor vehicle charged with criminal negligence. There was an accident, his passenger died. The issue was who was the driver of the vehicle. When he was come upon by passers-by, he was in a very bad state indeed. And initially, he said that he wasn't the driver. Then he said he was the driver. And again, the whole question of the operating mind of the accused was an issue. And Justice Spence in that case had stated, in my view, there is a further investigation of whether the statements were freely and voluntarily made, even if no hope of advantage or fear of prejudice could be found in consideration of the mental condition of the accused at the time he made the statements to determine whether or not the statements represented the operating mind of the accused. Well, to the degree that one might feel that Horvath and Ward have suggested radical expansion of the traditional rule regarding admissibilities in statements, and that they've given new significant grounds for exclusion, you must look to Nagacha and Rothman. The judgment of the court in Nagacha was delivered by the Chief Justice, and that involved an accused who was convicted of non-capital murder. It is clear that he gave statements. They were admitted by the trial judge, Mr. Justice O'Driscoll. Those statements were given at a time when it appeared that the accused, who was clearly a paranoid schizophrenic, might well have been. I thought Judge Riley would have got back to Kitchener after being in Toronto last night, but apparently not. It would appear that at the time he gave the statements, he might not have even been fit to stand trial. He was a very ill man. But he became fit, and insanity wasn't a defense on the trial. Justice O'Driscoll had found that the statements in effect were the operating mind of the accused. He said, "I do not find on this evidence that he was so devoid of rationality and understanding or so replete with psychotic delusions that his uttered words could not fairly be said to be his statements at all. Having come to that conclusion, it's my finding that the statements attributed to the accused should be admitted into evidence before the jury and let the jury decide what reliability should be placed upon them, if any." Now, it was urged upon the Supreme Court of Canada that no inculpatory statement by an insane person should be admitted in evidence, even if there was no promise of benefit or inducement or threat. The Chief Justice held, "It is clear that there was evidence upon which the trial judge could act in holding that the inculpatory statements were admissible, and it would be going too far to hold as an invariable rule that inculpatory statements by an insane man were ipso facto inadmissible." The principal argument put before that court was not the one to which I've just adverted, but rather that the trial judge had applied the wrong test, that he had applied the test in Santanon, a case in British Columbia, which was decided before the Ward decision of Justice Spence, and it was urged upon the Supreme Court that Justice Spence's decision in Ward was more favorable to the accused. The Chief Justice said no, that wasn't so, and inferentially states that the decision in Santanon and that in Ward are in fact the same, and that and he goes on, the Chief Justice, to say that merely because Justice O'Driscoll did not use the words operating mind found in the reasons of Justice Spence in the Ward case, it's no ground for saying that he used the wrong test. A trial judge is not bound by a fixed formula when he considers whether to admit inculpatory statements so long as he addresses himself to the proper considerations, and this he did in this case. You'll find that the courts more frequently, I think, are saying that fixed formula are not what is required, that, to use the words one of our justices of the Supreme Court, pettifoggery is passé, and so long as a judge has addressed himself to an issue, or a counsel, as you will see in Park, then it is not a matter for overruling the decision. So while the Supreme Court has ruled in Ward and indicated later in Rothman that to be voluntary, a statement must represent the operating mind of an accused, it isn't obviously prepared to state any general rule of incapacity. Now, Rothman, with respect to me in any event, indicates that that court has now perhaps reached its limit in the expansion of the grounds for exclusion of statements by accused to persons in authority. The case is fascinating in that it presents in the judgments of the majority and in the minority fundamental differences in approach to the exclusionary confession rule as it applies to statements given before trial by accused to persons in authority. And perhaps those decisions, that is between the majority and the minority, represent a fundamental difference in approach to the purposes of criminal law generally. I cannot urge upon you strongly enough the reading of the Rothman decision and the whole of that decision as being of exceeding importance and great interest and, frankly, almost in some cases, of literary value. The judgment of the six-man majority was delivered by Mr. Justice Martland, and Justice Esty delivered the judgment of himself and the Chief Justice in direct opposition to the majority judgment. Mr. Justice Lemaire delivered a judgment in minority, a judgment of his own, rather, which was perhaps closer in spirit to that of the minority, but found that the facts of this case did not operate to exclude the statement. The facts of the case were interesting in that the accused had been arrested in, I believe, Ottawa for possession of narcotics for the purpose of trafficking. He was cautioned by the police, taken to the police station, invited to give a statement, and unequivocally said, "I am not interested, I won't make a statement, that's it. Take me to the cells." And he was taken to the cells. Unknown to him, a police officer was placed in the cells with him, undercover, and a conversation started off with the accused firstly saying to him, "You look like a narc to me." The officer said, "Oh, no, I'm a fisherman, and I got caught speeding." "Oh, well, that was all right." And so they had a chat, and needless to say, the accused gave the officer a story which more than was sufficient to indicate he was a major dealer in drugs. Now, at the trial, the constable testified on the voir dire, and the trial judge ruled that the policeman was a person in authority, and the statement was inadmissible as having been improperly elicited through a disguise. He was acquitted. The Ontario Court of Appeal, in a majority decision, held that there should be a new trial because he did not, that is, the accused, did not consider the officer to be a person in authority, and that even if he had, the statements made to him were made voluntarily within the rule set out in Ibrahim. With that position, that of the Ontario Court of Appeal, the majority of the Supreme Court of Canada agreed. The test applied was a subjective one, in that the question to be asked was, did the accused, when he made the statement to the constable, believe that the constable was a person in authority? And the majority held that the constable was not a person in authority because he was not regarded as such by the appellant. Well, the ratio of the case is exceedingly simple. At page 37, it's stated, once it is accepted that the confession of the appellant was not made to a person in authority, and they say it was not, it was properly admissible without any requirement for the Crown to establish that it was voluntary. The confession was in the same position as if it had been made to someone other than the police officer, and it was an error in law to refuse to receive it. But Justice Martland didn't stop there. He went on to say, in fact, to assert that even if the constable had been found to be a person in authority, the statements would have been admissible, and that disapproval of the methods by which the statements are obtained is not a ground of exclusion. The only issue is whether the confession is voluntary or the utterance of an operating mind. Now, the majority considered the decisions of Horvath, Ward, and Nagacha, and in dealing with the first two, said, and this is what the Supreme Court of Canada majority now says those cases, Ward and Horvath, mean, quote, they are cases in which, although there had been no fear of prejudice or hope of advantage held out but to be by a person in authority, the confessions were excluded essentially because of the existence of a reasonable doubt as to whether the confession in question was the utterance of an operating mind. Through its discussion of Horvath, Ward, and Nagacha, the majority of the Supreme Court makes it clear that those decisions, in their view, were dealing with the question of whether or not the statement could be fairly said to be that of an accused, in that it was the product of an operating mind, and were not dealing with any question of police impropriety or court disapproval of police conduct, despite what you might have thought Horvath was saying through the hypnosis matter and the most sophisticated interrogation that had ever been seen by a trial judge. Now, in considering Rothman, there's an interesting decision of Regina and MacLeod, 1968, 5 Criminal Reports News Series at 101, which was a decision of the Ontario Court of Appeal, delivered by then Justice of Appeal Laskin. That case involved a deliberate ruse by the police designed to trick an accused woman into giving an inculpatory statement. And it was clear, however, in that case that the actions of the officer frightened her, and the court wasn't satisfied that her statement was voluntary. Now, the majority in the Supreme Court of Canada had no difficulty in distinguishing that case because they found there was an actual effect upon her mind, whereas there was not in the Rothman case. But what is interesting is that Justice Laskin, Chief Justice Laskin now, joining with Justice Esty in the Supreme Court of Canada in disapproving of the police conduct, in the MacLeod case, stated, page 104, in so holding, that is, in ruling the statement in MacLeod inadmissible, I do not rule out as a matter of law all stratagems that the police or persons in authority may employ in questioning a person under arrest. So it would seem that what's happened in Rothman is that the police have just gone to a stage beyond which to which he will not go or allow them to go. Perhaps that's the difficulty with the minority judgment, in that it leaves such a wide scope for the subjective views of individual trial judges to operate. An example, of course, is that of Justice Lemaire himself, who did not find the conduct of the police in this case to be sufficiently objectionable to cause exclusion, even though he held that a statement should be excluded if what was done or said by a person in authority would bring the administration of justice into disrepute. The majority decision has at least got the credit of certainty to it. Yet the decision of Justice Esty, while not law, ought to be read and considered as forcefully expressing views which are held by many engaged in the administration of criminal justice. His lordship refers to many of the same decisions as did the majority through Justice Martland, but he comes to a startlingly different conclusion from his examination of them. I must say this, that at Rothman at page 52, he states, this additional consideration connotes a recognition by the courts since the earliest times of the desirability and indeed the necessity of adopting a system of principles in the administration of justice which will be accepted by and command the support of the community. Thus it can be said that confessions are not admissible where to admit them would bring the administration of justice into disrepute, or to put it another way, would prejudice the public interest in the integrity of the judicial process. The decision is worth reading. I will not read great quantities of it to you, and it is not, of course, law at the present time, but it, as I say, does reflect an interesting polarity in the Supreme Court. Now, in himself finding that the statements should be excluded, Justice Esty applied the Horvath and Ward principles as he saw them to the facts of the case. And his findings finally were that the basic reason for the rule of exclusion is a concern for the integrity of the criminal justice system, which requires the support and respect of the community that it serves, that it strikes a delicate balance between the need to secure the conviction of the guilty, but above all to avoid the conviction of the innocent. And in this particular case, and he does rely on this, there was an express decision by the accused to remain silent, and that, of course, was just ignored by the police and by their ruse. It's perhaps not impertinent to state that the majority and minority positions in Rothman represent a marked divergence in philosophy. Now, going on to the matter of whether or not a voir dire is required in a criminal trial before the statement is admitted, you may recall the decision that I've earlier referred to of Irvin, which was discussed by Casey Hill and Harry Carlton 2 years ago. In the Irvin case, there was no consent to a waiver of voir dire, and in fact, counsel had objected to its being dispensed with. And in the Supreme Court, while they found that that confession was not admissible because a voir dire ought to have been held, there was a caveat in the judgment of Justice Dixon. And he said, further, I would not want to say that counsel may not expressly waive the holding of a voir dire in a proper case where all precautions have been taken. I do not express any concluded view on the matter of waiver, however, as there is no suggestion that defense counsel waived a voir dire in the case at bar. Well, in Ontario, there's been a long history of decisions which indicated that counsel could, in fact, waive a voir dire in a proper case. And those decisions were in direct conflict with the decision of Justice Manson of the British Columbia Supreme Court in Regina versus Lebrun, a 1954 decision. But the Ontario Court of Appeals, starting with Dietrich, said that it could be proper, and it's as recently as this year in Regina and Simpson number 2, 1981, 58 CCC 2nd at 122, that court has said, that is our Court of Appeal has said, that it could be waived. Indeed, in that case, in Simpson, Justice Martin said, we're all of the view that the learned trial judge was entitled to hold that the admission by the experienced defense counsel that the statements were voluntary constituted a waiver of the requirement of a voir dire, and he did not err in law in those circumstances in admitting the statements. The Ontario Court of Appeal in Clayton, 1978 criminal reports, Justice Arnott, in his decision, had said that until the Supreme Court of Canada was unequivocal in that matter, they were of the view, following Dietrich and Sweezy, that the counsel could expressly waive a voir dire. Well, there was a case called Park, one John Kenneth Park, and it was heard in 1973 before a judge of the county court in Toronto. And in that case, a voir dire was waived. The circumstances were interesting for this reason. In Park, he'd been charged with the offense of break and enter and commit theft. And according to the Supreme Court of Canada, he was at trial represented by experienced counsel. A statement made by the accused was of very great importance because the Crown's case depended upon an identification by a next-door neighbor. And that identification was not absolute. He was 99% but not 100% sure, and the circumstances in which the identification was made were really less than ideal. So the accused's statement was important because without it, there wasn't the necessary, in those circumstances, corroboration. And that statement was lengthy and it was exculpatory, but included one sentence, which was apparently or allegedly uttered when he was told he'd been charged with break and enter on a certain street and that he'd been seen coming out of the house. It was alleged that he said at that point, "That's no problem, the witness can't identify me, it was dark, and I've been to the barber since then." Of course, the position of the police was he hadn't been told anything with respect to the break and enter other than the location. He didn't know the time of day or the day upon which it occurred. The position taken by counsel throughout the trial was that while there was no question that the statement made by the accused, and the lengthy one, was made voluntarily in every sense, there was dispute as to what information had been given to the accused by the police and what exact words he said in reply. And indeed, it was disputed that he said the challenged comment. The trial judge accepted the police version of the events and determined the statement of the accused had been made and it had operated to corroborate beyond a reasonable doubt the identification. Now, to make matters a little worse, in the Park case, counsel having waived the voir dire said it's voluntary in all senses. The accused testified, and he said that both a threat and an inducement occurred. All right? Counsel had not cross-examined any officer in that regard. And when the accused made the comment, counsel did not ask either for a voir dire or a mistrial. Simply plowed bravely on. So the three issues before the Supreme Court of Canada, and as usual argued most ably by Edward Greenspan, argued ably, but I want you to note that he sat on the case for almost 6 years before he got to actually argue it. He just wasn't so confident on this one. The three matters that he argued were as follows: that the trial judge erred in failing to conduct a voir dire to determine whether the statement was voluntary and admissible, regardless of the fact that counsel had purported to waive the voir dire. That was the first point. Second point was that he erred in failing to conduct a voir dire to determine whether the statement was in fact made when there was a dispute as to its having been made. And thirdly, that he erred in failing to conduct a voir dire despite the waiver after the accused had himself testified that both a threat and an inducement occurred. Well, with regard to the right of counsel to waive the voir dire, Justice Dixon, for the court, in effect took the Dietrich decision, Justice Gale, and simply said, that's right. And basically, Dietrich said no particular, Dietrich had said, through Chief Justice Gale, as he then was, that it is an absurdity to require a voir dire when an experienced counsel decides that he can admit the underlying elements and that no voir dire need be held. The question of admissibility, according to Justice Dixon, of the statement is for the trial judge to decide, and he has a wide discretion whether to accept the waiver and dispense with the holding of a voir dire, or to hold a voir dire, or to inquire directly of counsel as to his understanding of the underlying factual admissions implicit in the waiver. In any event, it's now unequivocal. In a proper case, counsel can waive, and it is not. The court was given what was characterized as an in terrorem argument that, look, two things might happen. One, you might have a counsel who doesn't know what he's doing, and secondly, you might have a counsel who's less than honest, and he literally puts the court in a setup position in that he waives the voir dire, and then he has his client go in and testify as to threats and things like that, and the Supreme Court of Canada, I think, reasonably said, look, we are not going to formulate the criminal law on the basis that counsel are either incompetent or crooked. And given that trial judges have great discretion, they can cure these things if and when they should arise, and they should be rare, one would hope. On the issue of whether or not, well, by the way, Lebrun is clearly overruled by the Supreme Court in its decision, and the Dietrich position of Ontario is upheld. With regard to the right, well, before I go on to the next point of that case, on the issue of the waiver itself, echoing the words of Justice Laskin in Nagacha, when he was referring to a trial judge not having to use express formula, Justice Dixon said, no particular words or formula need be uttered by defense counsel to express the waiver and admission. All that is necessary is that the trial judge be satisfied that counsel understands the matter and has made an informed decision to waive the voir dire. Now, mere silence is not enough. There must be an express waiver, but it isn't magic as to how it is done. As to whether or not a voir dire is required when there is a dispute as to the statement actually having been made, that is, those words having been uttered, the court had little problem. They said, why do you need a voir dire? The argument had been you got to have some evidence that the statement was made. The court said, well, in every case in which the Crown alleges a statement was made, there's some evidence because there's a police officer who stands up and says he made a statement. That's a matter of weight, and that's for the jury or the trier of fact to decide, and that's precisely what the trial judge did in Park, and it was perfectly all right. He need not have a voir dire to determine it, and so if you've got a person who says, yeah, I made the statement, but not all of it, you needn't have a voir dire if all other in all other respects, the statement is voluntary. And finally, on the issue of whether or not there should have been a voir dire, when the accused got up and told about the threat and the inducement, the court said it wasn't necessary, that there were a lot of options open to the judge. He could have had a voir dire, he could have declared a mistrial, but his decision to continue was well within his right, so long as it was exercised appropriately, and he exercised it appropriately, his discretion, considering the waiver of the voir dire, the fact that there'd be no cross-examination of any officer in that regard, the fact that counsel was experienced, and the fact that there was no request for a voir dire or a mistrial when it occurred. Now, there are two decisions subsequent to these which are of interest, in which Horvath, Ward, and Rothman have been considered. They come from very different perspectives and they have very different results. One of them is the decision of Regina versus Griffin, 1981, 59 Canadian Criminal Cases, second series at 503, a decision of Justice Southey of our Supreme Court, which holds that Rothman in effect expands the grounds of exclusion of statements. In that case, the accused, his lordship found, had acted with complete propriety. But he ordered that a statement was inadmissible because, together with the length of time spent in custody by the accused and the accused's subjective and without cause thought that the police might beat him to get information and he'd better tell them something, that the statement had to be excluded. His lordship said that since there's a subjective test as to whether a statement was made to a person in authority, then consistency requires that the same sort of test be applied in determining whether a statement was obtained by fear of prejudice exercised by a person in authority. That is, the test should be as to what was in the mind of the confessor. If he confessed out of a fear of prejudice for which the authorities were in some way responsible, the statement should be inadmissible, even if the authorities didn't act improperly. Well, it's suggested with respect that the decision in Griffin should be examined carefully in the light of Rothman and also in the light of the decision in the Alberta Court of Appeal in Regina and Sawchyn, S-A-W-C-H-Y-N, 1981, 60 CCCs at 200. In that case, an accused charged with rape had given a statement which it was found by the trial judge was not obtained from him either by fear of prejudice or hope or advantage held out by a person in authority, but it seems that the accused thought that maybe if he gave a statement, he'd get out early. That was his own conclusion. It was not something afforded him by the police. Well, counsel had relied on Ward and Horvath and argued that regardless of the source of his motivation, a statement by an accused made with the hope that by it he'll obtain early release is not one made of his own free will. Justice Leecraft of the Alberta Court said, "This argument, if applicable to these facts, postulates a recent and sweeping change in the law of Canada relating to confessions. It urges the abandonment of the test of admissibility set forth in Ibrahim, adopted in Canada in Boudreau and Fitton. To say, however, that a statement is inadmissible whenever an accused has convinced himself that he will derive advantage from speaking is to render most statements inadmissible. In my view, the recent analysis of the authorities by Justice Martland, speaking for the majority in Rothman, makes it clear that no such profound change has occurred in the law of Canada." As must be evident from my opening remarks, the latter is a view which I share. Not in my paper, ladies and gentlemen, but something which came across my desk, and I'm sure yours very recently, in my case yesterday, is a decision of His Honor Judge Borens, who addressed you last week in that exemplary address on duress. And it's interesting to me in that it deals with Rothman. It's the case of Regina and DiNardo. It's volume 61 of the CCCs in part 1, page 52. DiNardo, you may recall from Demeter fame, if I am not mistaken. In any event, DiNardo was represented by Mr. Arthur Maloney, QC, Mr. Michael Wadsworth, and he was surrendered by Mr. Wadsworth after having spoken to both counsel to what they believed to be a parole violation warrant of some sort. And he was surrendered to a police officer, Sergeant Lewis, over at Bail and Parole, with express instructions by Mr. Wadsworth, look, my client has said he doesn't want to talk to anybody, he doesn't want to give any statements. if there is any attempt by officers to question him, would you please advise myself or Mr. Maloney forthwith? No problem, said Sergeant Lewis, and he trundled him off, and immediately upon inquiry found out that members of, I think it was the hold-up squad, were interested in him, and along they came, and they questioned him at great length, and they got an inculpatory statement. The matter went to trial before Judge Borens, and I'm sure you would agree with me that Judge Borens is a judge who listens with great care to matters which concern the liberty of the subject, and he considered the case and the conduct of the police as conduct which he would not approve. He considered the decision, which I'm sure you're familiar with, of McCorkle, one argued many years ago by Mr. Maloney, which involved taking of statements after a person had retained counsel, and then I think it was Justice Gale, as he then was, disapproving of that. Judge Borens admitted the statement, and he applied Rothman and the majority of the Supreme Court of Canada. He said at page 57, "While I may be of the view that the conduct of the police in this case in proceeding to permit the interrogation of Mr. DiNardo in the face of both actual and presumed knowledge that he was represented by counsel, it having been made clear to Sergeant Lewis that if the police intended to interrogate Mr. DiNardo about anything, counsel should first be contacted at the telephone number, represents conduct to which I cannot subscribe as appropriate in the circumstances. Nevertheless, I feel I'm bound by the statement of Mr. Justice Martland on behalf of the majority in Rothman that it is not a sufficient basis for the refusal of a trial judge to receive a confession in evidence solely because he may disapprove of the method by which it was obtained." Ladies and gentlemen, I guess you're aware that my thesis, to the extent that there is one, that there is a somewhat more conservative bent in the law in this area at this time, but I have no doubt that sitting as I do as a trial judge, that the ingenuity of counsel, which knows no bounds, will not be dissuaded in any sense at all by such conservative bent. Thank you.